Hey friends, we're back. Oh my God. It's been a long time. How are y'all doing? Everybody out there on the interwebs. Do me a favor as you come on in, hit the like button. Hit the like button as you came in. Damo's already done it. Damo already knows the deal. We are back with another Power Hour. It has been a little while since we live streamed, y'all, but that is due to good reason. Your girl is speaking at Vid Summit next week, so I've been very busy preparing, getting that presentation ready. It is finally done, so we can get back to regular scheduled programming. Hope y'all are all doing well. Reminder to hit that like button. We're going to cover a couple of topics today and a couple channel announcements as well. What we'll be doing moving forward is Tuesdays and Thursdays, we are coming back to Power Hour. Think of it like the Breakfast Club meets legal news, so to speak, right? So I will keep you guys up to date with everything that's happening Tuesdays and Thursdays. Right now, we're testing this 5 o'clock slot. And this Thursday, we're going to test the 12 o'clock slot and see which one works for y'all better. Right now, it seems like the channel is leaning female these days. I'm like, oh, okay. The ladies are here. They all came in with the Cardi B stuff. So it's really interesting to see how channel demographics can change. But we have quite a bit of stuff to cover in today's Power Hour. So as y'all pop in, really excited. Shout out to Carrie. Good to see you, Carrie. It's been a while. Sherry's in here as well. Petty Pendergrass. Gail at Night, the greatest mod the internet has ever seen. Brink is in here as well. Special Bendy Bros. Good to see you. It's been a wild, it's been definitely way too long. So here's what we're going to do. You guys have heard of the D4D situation, David. I don't know. I mean, I had not heard of this kid before everything that had been happening in California. So I'll give you guys an update on that. We're going to go to Atlanta and talk about some of the happenings with Miss Fani Willis, because on Friday, she got hit with a subpoena, okay? And it has not been a good month for Miss Fani. So we're going to talk about that. Also on the topic of Fani, I don't know if y'all heard about Tyrese. Did y'all hear about what happened to Tyrese? There was a warrant out for Tyrese's arrest yesterday because of dogs. I almost cried watching that video update. So we're gonna take a look at what's going on in Atlanta with Tyrese. Also, yeah, Fanny's got a lot going on. The Department of Justice wanting to get a grand jury to look into her travel records and things like that. Not a good thing. Not a good thing. I mean, James Comey, was it Friday got indicted? No, I think it was Thursday he got indicted. And then this DOJ thing comes out with Fani Willis less than 24 hours later. So we've got a lot to cover there. Young Thug, I was going to go live on Sunday, guys, but we wanted to make sure that we found the right time slot so y'all know when I'm going to be here. So the Power Hours, again, if you're just coming in, Thursdays and Tuesdays and Thursdays, the T's. We're here on the T's. That's how you can remember it. But yes, so Young Thug did a show in front of the courthouse on Sunday. Everybody's like, oh my God, is he violating his probation? What's going on? And I'm like, you know what? Let's look at this. It's very much likely that he had an agreement with the courthouse, and that was a part of his community service. If you guys remember, just about a year ago now, when Thug accepted his plea deal, and, you know, he ended up getting the final documents on what his probation was going to look like. One of the requirements was community service. My understanding is that that show was free for everybody that was outside in front of the courthouse. I mean, it's pretty cool aesthetically. I watched the stream, and yeah, they streamed it on his YouTube channel. Let's just say they should have called me. They should have called me for help. I could have set up all their stuff. I could have set up everything that they needed. I mean, they had multiple camera angles and all that, but you can tell when people are used to streaming versus not used to streaming. So it was apparent. Anywho, I bring up Thug because about 2-3 weeks ago, Judge Whitaker actually issued an order to get his stuff back from the state of Georgia. If you remember, when Young Thug was originally arrested back in 2022, there was a lot of items that were seized from his home. Cars, you know, jewelry, things like that, items of value. Judge Whitaker, in a recent hearing, I think it was like 2 weeks ago at this point, Brian Steele, I did stream it I either streamed it for y'all or I put up a video. It's about 20 minutes long. We'll, for those that are watching this on replay, for the replay crew, we'll include a link to that so you can watch it after. But Judge Whitaker sided with Brian Steele, and Young Thug was awarded his items back. Why Fani Willis? She appealed it. It's like, why do you appeal everything? You just got kicked off of the Trump case and you lost that appeal. Do you want another big L? Or do you want to see this L? So I have that order we're going to look at as well, because I could not believe the state was appealing that. And then lastly, Miss Karen Reed. I have not touched the Karen Reed case since a very, very unfortunate interview took place this summer. It's nothing against Karen Reed, but it was just a topic I wasn't comfortable covering anymore. But there's some movement in that realm. It was also a hearing last week, so I've got some time. It's about an hour long, and we are going to catch up and watch that hearing just to see what's going on. For those that are not familiar, we covered the Karen Reed case here on this channel, and she was acquitted, and that was the criminal charges. Now there's a civil suit that the family, and they had filed this, I think, in 2024 against Karen Reed. So we get to see a hearing on it. There was a motion to dismiss, and then the bombshell, and you guys already know, the bombshell came out where Karen Reed is actually suing the individuals that tried to try her on the case. So it's going to be very interesting to watch that. I have not seen it yet, so I'm watching it raw. For those that know already, like, try to keep it to yourselves. No spoilers, because you guys know the spoilers. You know who they are. They're always just, oh my God, Evie, like, this is what's about to happen. And the know-it-alls. We're like, all right, we know that you know, but I haven't seen it. So let's relax. Let's relax. Let me come to y'all real quick on some super chats, and then we will jump into today's Power Hour. Shout out to D, who's been with the damn D. D has been with me for 18 months. Says happy pre-birthday, AV. Thank you so much. D remembered. Listen, my birthday is Sunday, and I'm trying to still figure out my travel arrangements for Vid Summit. I know, it's bad. You should not book a flight the same week that you need to travel. It's terrible. I don't know what's wrong with me, but it's because I did not want to travel on my birthday. We will probably do a birthday stream on Sunday. I do it every single year. Typically, y'all come by, say happy birthday, but it will be open Q&A. So if you have any questions on any topics we've covered all year, or just have general questions about law, content creation, things like that, I do this Q&A every year. So really looking forward to that. But thank you so much for the birthday wishes, D. Your early birthday for sure. And you have a good memory, sir. Shout out to JC with the 5, says, what's up, family? Slat. Man, Thug was bugging for a little bit. I was really concerned about him over the weekend. He had some strange tweets going on at like late Saturday night. And then the show happened where, some people did know that it was going to happen, and they had to know. That's a big ordeal to have a concert in the middle of the street in front of the courthouse. So APD had to be aware, set that all up, things like that. All the audio and visual people, which they should hire me. They should hire me for sure. I mean, they should for live streaming. I'll set it up. I'll hook Thugger up, But thank you so much, JC. Shout out to D, who hits me with a 2, says AV7 from Media Relation. That's right. That is right. Cash Money Cash. Good to see you. Gail at Nights in here as well. Says my birthday is Thursday. Libras unite. It is Libra season. You see Lady Justice back there. It is Libra season. All right. Oh, look at that. Leisha, it's your birthday too. We got a bunch of birthdays coming up. That is amazing. All right, guys, without further delay, let's jump on into it and get into today's content, starting with D4D. So, David, okay, this situation has been blowing up mostly on TikTok, mostly on some of these shorter form platforms. I did 2 deep dives on it so far. So if you have not checked them out, please do. I give you a full case update. David is this 20-year-old singer. And at the beginning of September, his Tesla was found in front of a home, right? It had been parked there for quite some time, collecting dust, tickets, all types of things. Okay. So the car got towed after a few days of just sitting there, right? Because it was odd. The neighbors were like, "Oh, okay, like whose car is this? It's just sitting here." So car's registered to David. It gets towed, brought to a lot, right? They pop open the frunk because it is a Tesla, right? And I even did some measurements. I went into like the measurements of Teslas, the difference between a frunk and a trunk. The young lady was found in the frunk. Okay. Her body was chopped up into pieces. Okay. Like I believe it was a torso and some other body parts. The body was identified and the death certificate came out yesterday of a young woman named Celeste Rivas Hernandez. Okay. She is underage. David is 20. She would have celebrated her 15th birthday. I think she either turned 15 the day before or after. Now, internet super sleuths started super sleuthing. And this is why this thing is such a big deal, especially on TikTok. So the internet people started doing some digging on David. And when I say that, I mean they were looking at pictures to see if she was inside some of the pictures, see how they knew each other. There's a whole Reddit thread on it, and a lot of evidence started surfacing, right? I did another video on the difference between circumstantial evidence and direct evidence, because there's a big difference. David has not been named a suspect just yet. A lot of people are like, AV, that's crazy. He should be. There's pictures of him with this underage girl. She had run away from home multiple times. And there's live stream footage, like all of that stuff I have in another video for you. You can go and check it out. What I want to show you is the LAPD had not talked about this investigation publicly like all month long. Very minimal statements. They released a statement yesterday. So we're finally going to see what they have to say. It's very short. But a lot of people are like, David's guilty. Why is he hanging out with this young girl? You know, allegedly they met when she was like 10, 11, 12, one of them ages. Like they met in like a Discord group or something along those lines. But David is now an adult. You know, she's a minor still, or was a minor when they met, and even during the duration of whatever relationship they had. Now, the creepy part is that he has some pretty interesting tastes when it comes to music. Like, you know, Romantic Homicide is the name of one of the songs. He has a song named Celeste. So it starts to get a little creepy. And a lot of people started to get freaked out. Like, okay, what is the deal with this guy? Again, I have not heard of him since prior to this investigation coming out. A lot of people haven't, but he had his rise to fame on TikTok before he became a singer. Now, there are some people that are in the camp of David is innocent. And here's why. Because he was on tour around the time that the body was found. Okay. Now, the other interesting thing, and you'll see it in the statement that I'm about to show you, is that the time of death is a big, big factor in this case. Now, the investigation is going to take some time. Death certificate just came out yesterday. Now, a lot of medical evidence that was taken during the autopsy, some of those test results aren't available just yet, right? It takes a little bit of time before a full cause of death and some of those medical results, toxicology reports, things of the like come out. So I am going to keep my eye on that one for y'all. But let's take a look and see exactly what the LAPD said for the first time since this has come out. And yeah, we're playing around with some of the StreamYard new features. I haven't been here in a few weeks, y'all. So there's some new things. If you want to support the stream, ways to do that are on the bottom. We always put that there. If you want to send your girl a Cash App for me and my team to keep this channel going, that is how you can do that. But I did find a way to make myself a little bit bigger when we need to zoom in on things. But let's go with this view right here. So this is from the LAPD. It came out yesterday, and this is a news release. So this is the Robbery Homicide Division investigation into the death of Celeste Rivas Hernandez. The LAPD Robbery Homicide Division has been diligently investigating the death of Celeste Rivas Hernandez over the past several weeks. At this time, we can confirm that Celeste Rivas Hernandez is deceased and her body was found in the front trunk area of a Tesla belonging to David Burke. The vehicle had been parked at the location from which it was towed for several weeks. So Miss Rivas Hernandez may have been deceased for several weeks before the discovery of her body. Now, here's the issue with that, right? They're going to look at David's tour schedules, things of the like, but that means, because there's so many things here. One, David's home where he was staying with his manager, they were renting it, and I believe Halle Berry used to live there. They broke their lease. They're out of that house. They're done. They were like, we're out. We're getting out of here. That house was searched, and the LAPD was able to get a signed search warrant, a signed one from a judge. And you guys know the requirements to even get a search warrant. You have to prove that there's probable cause, that it's more likely than not that evidence is going to be found in that home. If her body was chopped into pieces, and I know it might be morbid for some of you guys, that chopping needed to occur somewhere. Where did it happen? And the best way that you can find trace DNA evidence with something like that is in drains, right? Drains, because typically, that's not going to be a pretty sight, and you would have to clean it up. So there's evidence. You guys know those like UV lights, all that stuff. Like, it had to occur somewhere. I think that's the biggest mystery in this case right now, is where did that happen and how did she die? Because if someone is going to go the extra mile, right, to do this to a child, number one, sick human being that would do that to a 15-year-old girl, and also, where does that level of anger or callousness come from? Like, what did she do? I mean, wow. To cut up this child into, man, it's just, we all have children in our lives, girls and boys in our lives and in our families. But wow, like, that is insane for someone to go to that level to do this to her. The creepy thing is that there have been videos of David talking about bodies in trunks and, body parts being chopped up. It gets crazy. It gets really crazy. Anywho, let's get back to the statement. It says the LA County Medical Examiner has not yet determined the cause or manner of Miss Rivas Hernandez's death. As such, it remains unclear whether there is any criminal culpability beyond the concealment of her body. Let's think about that. There's no criminal culpability beyond the concealment of her body? What are you talking about?
Bruh.
Like, what is that? So, all right, it's found in David's car. And I wonder if they meant, the body was found in David's car, that David doesn't have any criminal culpability aside from concealment of a body. But at the same time, if she had been dead for several weeks, the vehicle is showing, there was a lot of dust on it. It had been sitting there for a while. So the timelines need to add up here before any charges can be brought. But it's such a sad, sad situation. Anywho, RHD, so Robbery Homicide Division, is thoroughly examining every aspect of this case to uncover the truth and seek justice for Celeste Rivas Hernandez and her family. We appreciate the public's patience and understanding as we continue this investigation. Further updates will be provided as appropriate, but at this time, we are unable to answer additional questions. Now, what do y'all think, chat? Do you guys think that David had to know something about this situation? I mean, it's a car, it's a Tesla. I mean, there's so much tech in that car, and even just the app. Like I could see where my Tesla is right now. I could summon it. I could summon it to come and get me. Like all these things. Like it's a self-driving car, but you get alerts on your phone. Like, I just got one probably an hour ago. I left the door open, right? So you get these alerts. Is there a way that he had no idea where his vehicle was? Is very strange. I mean, and granted, celebrities often have multiple vehicles. Maybe you're just not using it or it was lent to somebody. How do you not know where the car is? There's so many questions with this one. But Brink says you'd think Tesla would just sell it with everything already set up, but now they don't do it. Yeah. Jerome says, I'm scratching my head like she didn't have friends. Yeah, that's the other thing. So her friends are saying that she was dating David. And like so that's I don't know if it's a confirmation that these two were in a relationship, but David has been allegedly cooperating with authorities and having discussions with them. A lot of people are not really rocking with him right now. His tour dates have been starting to get canceled. Some of his endorsements and deals he has going on behind the scenes have been canceled too. So it's not looking good. It is not looking good. Petty says, in the words of Little Woody, he did these crimes. I mean, I like it. Body handling legalities is wild. Can you believe that, UFO? I was like, what are they talking about? Okay. Switching topics. I mean, I don't know. I think everybody reserves, everybody is innocent until proven guilty, but it's just not looking good for David. That's all I can say. Some people are saying, there are some really diehard David fans out there, and they're like, oh, he can't be guilty. He can't be guilty. But it's like, why were you hanging out with this child? And we have y'all on a live stream. There's images of that. And in the live stream, actually, I'm not even going to spill the tea. I ain't even going to do it. You're going to have to go to my other video where, I have the live stream clip. But she said something along the lines of like, he raped little kids or something along those lines. So it's wild. All right. Let us switch gears real quick. That's your D4D update, David. Let's go to Tyrese. It's not funny, but what happened to this dog is not funny at all. Because I have Luna. You guys know I have my own little dog, and a little dog died because of Tyrese, and there was a warrant out for his arrest in Atlanta yesterday. Let us watch this video because I'm going to read the headline, and then we're gonna watch the video together. It says, police, Tyrese Gibson's dogs attack and kill a neighbor's dog. All right. I think I didn't watch the full thing. Hold on. Let me, let's make this big. Let's go, chat. This is hilarious. It's not hilarious, but I just couldn't believe that there was a warrant out for his arrest. You might not have sound on that. I'm struggle streaming, y'all. It's been a while. It has been a while. Sometimes you have to stop the screen share and then restart it so you can get sound. If y'all can hear it, do me a favor and put a 1 in the chat.
According to police, they've asked Gibson to turn himself in and surrender his dogs, but so far he has not complied. Fox 5's Eric Mock joins us now live in studio. And Eric, you spoke with the owner of the dog that died.
That's right. And, he's devastated. He said his small spaniel didn't stand a chance against these 4 large cane corsos, all of which can weigh upwards of 200 pounds. And what makes this pain worse for this owner is this isn't the first time actor and singer Tyrese Gibson's dogs have gotten out.
Crazy.
He was so loving. He was a little mischievous.
Aww.
He was a big kisser.
Look at the little dog.
For like 20 minutes every time I got home. and we were inseparable.
Harrison Parker says his King Charles Cavalier Spaniel, Henry, was the best dog anyone could ask for.
It's so
Parker says on
cute.
September 18th, he let Henry outside in the front yard of their Buckhead home on Woodhaven Road like he had for years. He says Henry was well trained and never left the yard. But after he didn't come back for a few minutes, he went outside to check on him and found the little dog dead in the driveway. He rushed him to a pet hospital, but it was too late.
Apparently, he died very quickly from internal bleeding. He was crushed. I mean, the doctors were like shocked, like he had multiple ribs broken. I mean, it was horrible. Like, I really hope his suffering was quick.
Police say Henry had been mauled by 4 large cane corsos. Those same 4 dogs were captured on a neighbor's security camera across.
Listen, why are Tyrese's dogs just running amok like that? You see, wait till they tell you guys about this story. So Tyrese's dogs, this is from another neighbor that lives across the street. The dogs are mauling at her door. There's 4 of them. 4 of these dogs are mulling at somebody's door. They're out. They're not leashed. They're not any, like, oh my God, Tyrese. Like, watch your dogs.
The street. The neighbor called Fulton County Animal Control about an hour after Henry was killed because she didn't feel safe with them pawing at her front door. Fulton County Police say the dogs belong to Fast and Furious star Tyrese Gibson, who lives just around the corner on Tuxedo Court.
There have been multiple calls of incidents of these dogs escaping over the past couple of months.
Captain Nicole Dwyer with the Fulton County Police Department says records show Gibson's cane corsos got out at least 3 times this month prior to the mauling. Animal control officers tried to cite Gibson for the violations, but he wasn't home when they stopped by. Parker is furious that Gibson didn't do something then to keep his dogs on his property.
He didn't care. I mean, what a jerk. He's just letting these dogs run around, whatever.
Captain Dwyer says she called Gibson after Henry was killed and explained he needed to surrender the dogs, but he refused. So they got a search warrant for his home and an arrest warrant for Gibson for animal cruelty, which they executed on September 19th.
He was not at the residence, and neither were the dogs. They had already been removed. So at this
Hold on. Did they just say that they had a search? Hold on. Let's go back. On the 19th?
point, the resident
For animal cruelty, which they executed on September 19th.
He was not at the residence, and neither were the dogs. They had already been removed.
Wow.
So at this point, he is wanted for cruelty to animals, and we're asking him to turn himself in and turn the dogs over to animal control.
Dwyer says they've given Gibson a week to do the right thing.
We had spoke to his attorney that he was possibly going to turn himself in by last Friday, but that did not occur. And now we see on his Instagram as of Saturday that he's posting that he's going on a mental health journey, and he'll be in Dubai until November.
She's worried if they don't get the dogs soon,
They'll get out again, kill another animal, or heaven forbid a child or someone just walking.
Parker wants justice for his best friend, no matter how famous the suspect is.
He didn't do something about it. He didn't take it seriously. And now a wonderful life is dead, you know, and I'm never going to get him back.
We tried to reach
Tyrese,
Gibson
wow.
by phone, and I left a message with his attorney, but we're still waiting to hear back. Now, Captain Dwyer says despite Gibson's celebrity status, they're going to treat this case just like they would any other animal cruelty case, and that's why they say it's so important for him to turn himself in and to surrender these dogs.
Yeah, interesting timing taking the trip out of the country. But your heart just goes out to this man who lost his dog, and you just look at the sheer size difference of those dogs. It really is.
It doesn't even compare. This dog was so small compared to these 4 massive dogs.
Yeah, there's no reason why they should have been free. And you can understand his heartbreak and his anger.
Exactly.
Eric,
All right.
thanks.
Thanks, Eric.
I can't believe Tyrese is he's out of he's out of the country. Maybe that's why those dogs were running amok. Who was watching them? And you cannot tell me, Tyrese, I know you're going through the divorce thing with Samantha. Was her name? Sammy. You're going through the whole thing with Sam, with the divorce or whatever, and the child support stuff. But you can afford like a place for those dogs to go, boarding or something. Tyrese, you got it. You got it. But oh my goodness. They said he's in Dubai. Oh, I'm on a mental health journey. And they're like, you've had a warrant out for your arrest since September 19th. That's a long time. That's been a few days. So, wow. this whole, I mean, the whole animal cruelty thing, I couldn't believe that. I was just like, why is there a warrant out for Tyrese's arrest? And then when I saw that clip earlier, I was like, oh, I got to share that with the Chatterhood later. I could not believe it. Could not believe it. Let me grab a few more of these super chats real quick, guys, and then we're going to move on. We're going to stay in Atlanta and get into some Fani Willis news. There's always something. There's always something. Shout out to Exelis with a 5. Thank you so much. Says there's no end to the scrambling and scraping from Fani. Keep it up, AV. Yeah. And then Nathan is suing AT&T. I did a deep dive on that for y'all last week. He is suing AT&T because Ashley Merchant asked for his phone records, and she got them. They gave it to her. They were like, here you go. Here you go. So Nathan's pissed, and then he filed a federal lawsuit against AT&T. I couldn't believe it. It was hilarious. But he talked about how it was unfair and it was a breach of privacy, even though she followed the right rules of, asking for the information, was turned over. But he was arguing that it was because of the first net plan that he was on. So there's a specific type of plan on AT&T for first responders, firefighters, public servants, things like that. I was like, well, is a prosecutor a public servant? And you're not in that job anymore. So why can't she have the records? I don't know. But apparently he was in that plan. So he's fighting AT&T. But yes, there is lots of Fani news for us to catch up on. Thank you so much, Exelis. Nay, our favorite Aussie, has been with me for a year. Says, hey, AV, happy early birthday. Thank you so much. And thank you for all your time with me. Yeah, C. Cooper, we cut up in the chat. We have fun. Enjoy the scrambling and scraping. I did talk about Miss Love a lot when she would, you guys remember when she would glitch out, like she was thinking and she would just stop and just freeze. Like that's what would happen. I'm like the scrambling and scraping. Brink knows what I'm talking about. She got slimed. I think I saw her in the courtroom probably a month or two ago. She was on another case. Okay, let us shift gears to Miss Fani Willis, and then we will jump into the Karen Reed hearing. It's about an hour long, so I'm going to be hanging out with y'all for a little bit. Okay. Miss Fani Willis, chat, is she's like the Department of Justice is now involved, okay? So I brought up the whole Nathan thing because it's kind of semi-related. What does the DOJ want from Fani? Okay. She now they want some of her records. Okay. This was a few days ago, the 26th, I think it was Friday. Here's what they want. The U.S. Department of Justice has issued a subpoena for records related to the travel history of Fani Willis, the Atlanta area prosecutor who charged President Trump in the election interference case. The New York Times reported on Friday. The Times said it was not clear whether Willis is a target of the inquiry or whether she will ultimately face charges herself. Can you guys believe that? Imagine if Fani Willis faces charges. And you know Trump is going to love that. I mean, he was already talking about it on Friday. He was just like, Fani has been going after me for a long time. She's a criminal. She needs to be jailed immediately. Immediately, her and Lover Wade, they went after me. And now she's rightly taken off of that case. She shouldn't have bought it in the first place. There was an odor of mendacity. Lover Wade is what I call him. Lover Wade. She needs to be in jail. She's a criminal. I'm like, oh, here we go. But yes, he's already elated that this is happening. Representatives for Willis and the DOJ did not immediately respond to Reuters' request for comment. Willis, the Fulton County District Attorney, charged Trump and 18 of his allies in 2023 with conspiring to undo his narrow defeat in the battleground state in the 2020 election. The defendants include former Trump lawyers Rudy Giuliani and John Eastman and former White House Chief of Staff Mark Meadows. But the Georgia prosecution, once seen as a significant legal threat to Trump, ran aground when the appeals court disqualified Willis from the case and ruled that her romantic relationship with the former top deputy, Nathan Wade, created a significant appearance of impropriety. Georgia's, and she appealed it. This happened last December. Georgia's Supreme Court declined to review the case earlier this month. So she appealed it last year, finally went up to the Georgia Supreme Court earlier this month, and they said, Fani, no, enough. So they're like, we're not looking at this again. The DOJ filed criminal charges against former FBI Director James Comey on Thursday, the day before, in a dramatic escalation of Trump's retribution campaign against his political enemies. Trump has threatened to imprison his political rivals since he first ran for president in 2015. The DOJ in his second term is also investigating other antagonists, including the New York State Attorney General Letitia James, he does not like her, and John Bolton, who was a national security official in Trump's first term. That's what Reuters reported. Now, so Steve Sadow, you guys know that he is Trump's attorney in this election interference case. He put something else out as well, just kind of co-signing it. And he's just like, oh, and don't forget, the trial court did say that it was an appearance. It was an odor of mendacity, that she was caught lying. So he kind of added on Twitter, I think it was yesterday with that one. He posted this. I mean, it's a very, I don't know why it looks like this. It doesn't really look like a news article, but basically it looks like this was lifted from Atlanta News First. Basically, it says the news went from bad to worse for Fulton County District Attorney Fani Willis on Friday, a week after being permanently removed from the election interference case she began against Donald Trump. The Times reported that Trump's own Justice Department had subpoenaed records related to her travel. If they're looking for her travel records, this probably involves Nathan Wade. Like, they're wanting to see if they were traveling together, I believe. So that's going to be interesting. Why the department has asked for the records is not known, but the news one day after James Comey following Trump's vow to jail his enemies, one of those enemies is Fani Willis. It takes a striking turn of events for Willis, who started in 2024 as nothing less than a national Democratic superstar. That's right. The fall from grace is real. The DA had successfully bought what looked like the strongest criminal case against Donald Trump in the country, a 41-count racketeering, because we know Fani loves RICO. She loves her RICO. And his allies of illegally trying to overturn Georgia's 2020 elections. A highly touted book, Find Me the Votes. Oh, I forgot about that. I wonder if she's still selling them. Let's go to Amazon. Is Fani Willis still selling that book? Find Me the Votes. It's still here. It's still here. Well, wait. Yep, it's still here. Find Me the Votes. A hard charging, I need to pay my Prime bill. Find Me the Votes. This is the book right here. A hard charging Georgia prosecutor, a rogue president, and the plot to steal an American election. That book. So she didn't write it. It's through Michael Isakoff. I remember this from the hearings, right? So that, very interesting that book is still being sold, but it's up there. Find Me the Votes puts Willis on the cover and casts her as the David to Trump's Goliath. And any conversation about rising stars in the Georgia Democratic politics invariably included Willis as one with intentional visibility, a national fundraising base, and serious statewide potential among Democratic voters down the road. But just a week into that year, Willis and the entire Trump case were rocked by a mind-boggling accusation that turned out to be true. The DA had begun a romantic relationship with Nathan Wade, the same married prosecutor she tried to hire to lead the case. After 2 days of tabloid-flavored court proceedings, wild enough to be an episode of the Jerry Springer Show, Willis was eventually removed by the case by the Georgia Court of Appeals over the mere appearance of impropriety that the affair created. Last week, the sputtering case was finally put on ice. officially taken out of Willis's hands by the Georgia Supreme Court and sent to the dustbin of the Georgia Prosecuting Attorneys Council, the same group that took nearly 2 years to decide not to prosecute Burt Jones in the case. Lieutenant Governor Burt Jones in the case will now be tasked with finding a prosecutor somewhere in the state with the time, money, and appetite to pick up where Willis left off. Don't hold your breath. Attorney Michael Michael Kay, a constitutional law professor at Georgia State College of Law, said Willis should have known the scrutiny she was bound to be under and acted accordingly. The idea that a local district attorney was going to take on the former president of the United States at the time, some of his most powerful and well-known allies in the country, and not make sure that every T was crossed and that every I was dotted and nothing remotely was done inside that office that was beyond reproach is laughable. Wow, people are laughing at Fani and the legal community down there, huh? In other words, Mr. K here, Michael K, says, if you come for the king, you best not miss. The Supreme Court decision finalizing her removal was the latest blow for Willis in a year that has had many. They're counting the L's. Along with the Trump case debacle, Willis's office finally brought to a close the YSL murder case, Willis's other massive racketeering case that she started since she took office. That case limped to a close without a murder conviction from any of the original charges. That's a big L. Like the Trump case, Willis targeted a powerful force. In this case, Atlanta's famous rap community, putting all artists on notice in a news conference after launching the indictments. This is what she said. You ready? I have some legal advice. Don't confess to crimes on rap lyrics if you don't want them used, or at least get out of my county. Fanny, what you talking about? Willis is right. I'm like, oh my God. She was very aggressive. She's just, don't confess to crimes. And it's like now, and over the past few weeks, everybody's been talking about ratting and Ratlanta this and Ratlanta that, and then all these leaked phone calls with thuggers coming out. Fanny's like, don't be confessing to crimes and rap lyrics. That's your evidence? Anywho, by the end of the saga in June, the Atlanta Journal-Constitution reported that legal observers called the events that unfolded in and out of the courtroom a circus and an embarrassment. The mother of one murder victim called the outcome a long way from justice. I think that's either Shamel Drinks or Donovan Thomas's mother. Also, a long way from justice is the outcome in the election interference case, which included charges against the Trump campaign allies for allegedly breaching Coffee County voting machines, as well as harassing Georgia poll workers, Ruby Freeman and Shay Moss. Above and beyond the case against Trump, these allegations deserve a thorough investigation and resolution of risk being a green light for repeat behavior in the future. The good news for Willis, and there is some, is that apart from the high-profile RICO cases, crime in the city of Atlanta is going in the right direction. What is it? The city's homicide rate is down 32% from this time last year, which is down from the year before that, and even better than the top 17 drop nationwide. Fulton County voters rewarded that and returned Willis to office in 2024 elections with 68% of the vote, well after the Nathan Wade scandal broke. Well, I didn't vote for her. I didn't do it. I voted in Georgia. I didn't vote for her. I voted for the other person. Here's why, as a Fulton County resident, I didn't vote for her. I think I told you guys about the day where somebody had broken into my house and stole a bunch of luxury items. And I'm from Massachusetts. So moving to Georgia, I'm thinking police are going to do their jobs. And we're about to talk about Karen Reed, but the police are going to do their jobs. I think they're going to do it, right? They just had all this justice for this dog They put a warrant out for Tyrese. Dogs get more justice. That's crazy. Anyway, called the officer or called 911. It took them like 20 minutes to get to my house. They came in, looked around and told them what happened, and like never heard from them again. Open and shut case, Johnson. That was it. That was it. So I was like, okay. Can't get my stuff back. $5,000 worth of things stolen from the house. And like, they didn't really care. APD was just like, all right, file a report, call this number. I was like, aren't you supposed to do that? I'm like, okay, whatever. So I was not very impressed with crime in Atlanta and in Fulton County. So she didn't get my vote. Teron Johnson, a Democratic strategist, and Willis has never expressed higher electoral ambitions to him other than being a great prosecutor and putting bad people in jail. But her victory over longtime incumbent Paul Howard in 2020, an it factor at campaign events, and her national profile after indicting Trump thrust her into Democratic's shortlist for future contenders anyway. She is not on the short list now, but Johnson added down the road, I'd never count her out. But Friday's news about the Justice Department subpoena changes the conversation entirely. Although there was no illegality ever alleged during Willis's removal proceedings, Trump has shown that he is more willing to go after prosecutors who went after him, including Fani Willis. Wow. So that's what you have. And there's more. That's her DOJ thing. So the Department of Justice is coming after her. Okay. Now let's move on to some thug news. So with the thug news, when it comes to Fani doesn't give up. You guys know that. Thug just had a win with Judge Whitaker because he's just like, he's been doing his community service. He just had this show this past Sunday, and he's been, staying out of the news, at least criminally. He's in the news with the jail phone calls, like all that's happening. His album just dropped. It's actually pretty fire. So if you have not checked it out, please do. But Fani doesn't give up. Here's how you know she doesn't give up. Judge Whitaker made that ruling. Guess who's appealing it? Miss Fani Willis. Let's see what she says here. Why is she appealing the fact that Thug wins his $149,000 worth of stuff back? Let us see. The state of Georgia hereby appeals to the Court of Appeals, the state of Georgia, from the order filed in the above styled case on August 25th, dismissing the complaint for forfeiture. The state of Georgia initiated this civil suit for forfeiture of personal property from a criminal enterprise. She's still calling. Is YSL still a criminal enterprise? I thought we just... Okay. This is an appeal of the Superior Court order which dismissed the complaint. Given that order, the case is no longer pending in the Superior Court. Here's the statutory authority that they're using. So they're using this statute. Although the state is limited in what can appeal in a criminal case, it appeals in this matter as a party in a civil case. Oh my God. Further, the order at issue here is directly appealable as it is a final judgment. We're going to skip that. Let's talk about the timing. The Superior Court issued its order on August 22nd. The state files this notice of appeal on September 19th. This notice is timely. Record on appeal, the state requests that the clerk will omit nothing from the good record on appeal. So this is a certificate regarding transcripts. That's fine. Jurisdiction is fine too. All right, yeah. This notice respectfully submitted on this 19th day of September. So that's floating around too. Here's a certificate of service. So they served Brian Steele with this. I still can't believe, just let Doug have his stuff. Like, why? Just let him have his stuff. Thank you, Keyshawn. Hot girl Fanny, give that man his stuff back. That's it. That is it. All right, guys, we're going to shift gears to Karen Reed. But, definitely want to come over to some of the super chats in between that. Shout out to Jamie. He's been with me for 4 months. Thank you, Jamie. Says happy early birthday. Thank you. I appreciate it. Full birthday is on Sunday. A little bit of a preview, but we're almost there. Thank you, Jamie. Really appreciate it. Senator, shout out to Senator with the 5. Thank you so much. He says, AV. Guys, Senator has a channel. Senator, can you drop the link to the channel, to your channel in the chat? I caught it the other day because he tagged me in something. It's over here. I showed you guys a candle that he made. He actually makes candles and they're very, very cool. So I appreciate the shout out, Senator. And you guys go check out his channel for sure. Deanna with the 5 says, Fani going to change her name to Lanny after all the L's. I mean, there's a lot of L's here. There's a lot of L's here, D. There's many. There is many. Okay, we are shifting gears over to the Karen Reed hearing that took place last week. Remember, this is the wrongful death lawsuit. If you have seen it already, just try to keep, no spoilers. We all want to see what happened. So we're going to go over there and check this out. I have not seen this yet. So this is the O'Keefe family versus Karen Reed. And we also find out that Karen Reed is suing many, many people as a countersuit.
Anything over while the criminal matter was pending. So we're still trying to get all the documentation in.
Okay, but just if I can follow up on that, the stay that was issued, Judge White had issued one back in maybe the fall. I had issued one when the criminal trial was ongoing. That was sort of a self-defining 60-day or whichever comes first. So that should be pretty much in the rearview mirror for now, right?
I recognize that, Your Honor. Right. So when the stay was lifted, all discovery was served on the parties or thereabouts.
When you say discovery, we're talking about depositions, documents, notices of depositions or no?
Only one deposition has been noticed and it's been tabled because we don't have any documents at this stage.
I see. So it's really the paper discovery that you're looking for. And when you say the DA's office, that obviously is not the defendants, that's going in a different direction, but you're pursuing that sort of on your own?
Right, but we've also, I anticipate that the defendants have all the same data that was exchanged during the criminal matter to which we haven't ever received. So we have requested that both from the defendant and we've requested it from the DA's office.
Okay.
It is coming in from the DA's office in parts, and I anticipate we should have it all within the next 21 days is my guess.
Okay. All right, procedural issues from the defendants. We can start with you, Attorney Seligson.
Thank you, Your Honor. As we're anticipating the status of this case, it's important to inform the court that from Ms. Reed's perspective, we have affirmative claims that we intend to bring on her behalf. Those claims stem from the same facts that are at issue in this case. Those claims, Your Honor, are against parties that are not in the litigation at this point, including the Massachusetts State Police, Lieutenant Brian Tully in his personal capacity, Sergeant Yuri Buchanan in his personal capacity, Michael Proctor. Those claims would be in the nature of violations of Karen Reed's civil rights and conspiracy. The claims against the Massachusetts State Police would be negligent training, supervision, and retention of Massachusetts State Police troopers. We also intend, Your Honor, to bring claims, affirmative claims, against Brian Albert, Nicole Albert, Matthew McCabe, Jennifer McCabe, and Brian Higgins, who are the occupants of 34 Fairview Road in Canton.
Wow.
Those claims will be in the nature of civil conspiracy, violation of Karen Reed's civil rights, and then a claim against the town of Canton through its police department for negligent failure to secure the garage in the Sally Port. We asking the court's permission to bring those claims in this case because they do arise out of the same nucleus of operative facts. In order for us to fairly defend Ms. Reed in this case, those claims, those parties need to be asserted in this case. What we'd like to ask the court's indulgence for is we have a proposal of how to bring those claims in, given the voluminous nature of this case. That would be 10 additional parties coming in. To do that, we would be alleging that the individuals in the house diverted attention away from themselves towards Ms. Reed, that law enforcement then acting on that diverted attention away from her, because the people in the house were either police or police adjacent who were socially and personally connected, then they collectively conspired to ensure that what happened in the house was not explored and investigated. And instead, Ms. Reed was wrongfully targeted, maliciously prosecuted, made to face 2 criminal trials for the death of John O'Keefe, and is now facing allegations of wrongful death, all stemming from the same claims. How do we synthesize the process to bring these claims and parties in? What we're asking the court to consider is for us, at the time we file her answer to the complaint, we've got some claims that we're asking to be dismissed, regardless of how the court decides those. We still have to file an answer on her behalf. Our suggestion would be to file those claims against those parties in the same pleading. Serve all of those new parties with that complaint. Allow them 30 days, not the normal 20 days, to respond so the court can have one hearing on whether some may bring dispositive motions, some may file general answers, so that we can then decide how and who is in the case and proceed forward. So I bring that to the court's attention. And I'm happy to brief it so that Mr. Dillard can have an opportunity.
Well, at a minimum, you're going to do that. I'm envisioning what the plaintiffs are going to say to this rather extraordinary process, but go ahead.
But that would be, otherwise it's going to be a very unwieldy, delay-inducing process, and we're not looking to do that. This accounts for trying to conserve judicial resources, trying to have a streamlined approach, at the same time making sure that all the claims and all the parties are in this case. The alternative would be for us to file a separate action on Ms. Reed's behalf, alleging these claims, and then move to consolidate immediately with this case, which Your Honor has broad discretion to allow. The point being, the claims should be in this case. They all arrive out of the same facts. They're not separate. And that's essentially what we'd like to do. We'd like to brief that, Your Honor, and have the plaintiffs respond and then proceed from there. Okay.
All right.
So that's interesting, guys. So this gentleman is a part of Karen Reed's civil defense team. And what she is saying is, okay, if the O'Keefe family is suing me, I have some counterclaims against all of these people, the 3 cops and all the people that were inside of the house as well. So she's bringing in other parties. Now, what this lawyer is arguing is to kind of make it simple by bringing it all in one lawsuit. And you do need to run it by the O'Keefe family as well. So we'll see what the judge says here. My inclination is that they're probably going to do a separate civil lawsuit that is initiated by her and not really bring it into this O'Keefe family case. But let's see what happens.
Let's hear it then from the Waterfall.
Yes, Your Honor. We are in the process of completing written discovery propounded to us from the plaintiff for under extension until next month. We anticipate that will be completed then. We as well.
When you say an extension, this is an agreed to extension? Agreed. Because the tracking order is what it is. We'll get to that in a little bit.
It's been agreed to, Your Honor.
Okay.
And then, Your Honor, we're looking at depositions, but we don't want to consider noticing depositions yet until a lot of the document requests have been answered in the subpoenas for keeper of records. We haven't seen any of the records. We're aware of them certainly from the criminal trial, but when there are a lot of records, as I understand it, that are still to be produced, so that we would then proceed with depositions as warranted in conjunction with counsel and obviously picking dates that work for all. But that's what we foresee in the immediate future, Your Honor.
All right, thank you. Let's hear from C.F. McCarthy, then.
Your Honor, on a similar vote as to Waterfall, we were putting finishing touches on our discovery responses. The last leg of it is just collecting communications from employees related to the incident, some of whom no longer work with C.F. McCarthy's, but we anticipate having that completed in the very short term and getting that over to my brothers.
Okay. All right, thank you. Let's hear from the plaintiffs then in terms of the response to the procedural issue that was raised in particular by Ms. Reed's counsel. Are you aware of the circumstances that they're seeking to join 10 additional defendants into this action?
Absolutely not, Your
It's the
Honor.
first notice you've gotten?
Of course, I would
Not how the
expect
court
that.
system likes this stuff to work, folks.
Right, I would expect the courtesy of the meet and confer to at least let me know. Obviously, they can choose not to do so. That's their prerogative, but I certainly would have liked to have been made aware. Section 1983 actions, I believe, Your Honor, would have to go up through the federal court. We're not seeking to have this case removed in the federal court. We started in the state court. We're intending to move forward in the state court. We would like to have a state court Plymouth jury decide this case. So to the extent that my brothers and sisters and all of those who are involved believe that they have other legal rights and they want to pursue other legal theories, that's their prerogative to do so. When it comes to interfering with our opportunity and right to justice, we're not looking to sideline that, Your Honor.
All right. Any response, counsel?
Thank you, Your Honor. We are asking for permission to serve a motion to advance this procedural proposal. So Mr. Diller is not being surprised by the argument that we're going to present to the court. He will have an opportunity to respond. There's no requirement that civil rights claims be brought in federal court. In fact, this court has jurisdiction over those claims. They all stem from the same facts, Your Honor. In the plaintiff's complaint, there are allegations that we need those parties to defend against. This is not just a wrongful death action. Our narrative of what took
But it
place.
is, though. It's the plaintiffs. Well, just hear me out for a second. And when you say that it's not just a wrongful death, that's what the plaintiffs have alleged. The defendants have filed motions to dismiss portions of those. So this, at its essence, is a wrongful death action being brought by the plaintiffs, right? So what you're seeking to do is to be allowed to amend these proceedings and to effectively bring in 10 other defendants for the claims that the defendants have against those third parties that aren't noticed here, right? So you've got to procedurally give them notice as well as the plaintiffs notice of this event before it goes to any adjudication by the court.
And that's what we've built into this proposal, which is trying to streamline that process, not depriving them, the new parties, of the opportunity to argue both the procedure as well as the substance. And we're suggesting, instead of serving party X with a third party motion for a complaint, then that party opposes it, then the court rules, then that party perhaps is brought into the case and then brings another motion to dismiss substantively. We're not seeking to...
Isn't that what the rule requires?
The rule does require that, but the court has discretion to consider the streamlined approach. And we'd like to brief that for Your Honor, but we're raising it at the status conference so that because we are scheduling deadlines and events out into the future, we'd like to at least have the opportunity to advance that argument for the court and allow Mr. Diller to respond to it. And then we will act accordingly. That's the purpose of the disclosure of this today, Your Honor.
All right, so I don't know that there's any ruling by the court today that would have to be made relative to that because it isn't even filed yet, so that there's nothing before the court. So ideally, what my instructions to the clerk's office by setting this event up was to get a trial date from you folks and then work backwards like we would do with any wrongful death tort action, which this case is. I take exception to the defendant's notion that this is not just a tort action. It is. That's what it is. It's a civil case. I know there's a lot of people who are interested in this case, but at its heart, there are at this time eight parties involved in this case, correct?
Yes,
There's 5 for the plaintiff, and there's 3 for the defendants, 2 corporations and Ms. Reed. So that's the way the case is shaping up. You've got your tracking order, so you understand what the deadlines are now. I have the tracking order, I think basically shows this case as having discovery Yeah, your discovery is supposed to close August of next year. Your Rule 56 motions to be done by October-ish of next year. Final pretrial conference February of 2027 with judgment by August 26th of 2027. So that's what the tracking order has in store as the case stands
Dang.
now, right? I mean, we could get you a trial date way sooner than that if you wanted to. I mean, literally, I could, the clerk and I were talking earlier before today's proceeding, and I may end up having to suspend, depending on what the circumstances. We were charging the jury on a homicide case earlier today. So we have a deliberating jury right now, so I don't know that I may have to suspend and then rejoin here in a little bit. But for now, so you understand it, we could get you a trial date as soon as practically this spring on this case. But to join 10 new defendants under wholly separate theories for people that haven't even been joined yet in this litigation puts that on its head. There's no way you wouldn't even have this procedural process outlined by the spring, most likely.
I understand that, and that's the dilemma that we're trying to bring to the court's attention, because there is going to be an affirmative pursuit.
Well, you're saying you said earlier affirmative defense in this case, which those would not be affirmative defenses. Those are wholly separate third-party causes of action against people who are not part of this litigation, correct? So it's not an affirmative defense.
It's not an affirmative defense in the traditional sense, but it is part of the defense in the face of the wrongful death claims. The wrongful death claims stem from the same facts that the affirmative claims would be seeking to be pursued against. So it is the same set of facts. If we were to file a separate action, Your Honor, where Karen Reed is the plaintiff and these parties that I've identified are the defendants, we would be pursuing down two separate pieces of behemoth litigation when we can consolidate them at the same time. That's what we're trying to suggest may be a more streamlined approach. And it's not intended to delay. It's actually intended to try and synthesize the process and conserve resources, attain judicial economy without prejudicing the plaintiff. Discovery is already ongoing. But to have two depositions, for example, of parties in two separate cases, where we can have one and the claims could proceed at the same time, just seems to make judicial sense. That's why we're raising it. But we'd like to brief it if the court gives us that permission.
Okay. All right. On that last discrete issue, anything else from the plaintiffs?
We have served them with discovery, asking them, they have a burden if they're going to do affirmative defenses to establish that there are third parties who are responsible here. That can be their affirmative defense, but they have a burden to prove that. And if they can't meet that burden, then it should never come into our case. If they're seeking to overlap these two cases and throw it as far wide ranging as they've just announced, then there's no way that we would not be prejudiced by their strategy in the plaintiff's underlying case.
All right, those issues are reserved. I'm certainly not going to make any ruling on that. There's nothing formally before the court, no written motion, no Rule 9A or 9C certificate, none of that stuff. So it's not procedurally before the court, but certainly I appreciate hearing the argument nonetheless that this may be the future landscape of the case. What also brings us here, when I noticed the status conference for today, the defendants have filed motions to dismiss. If you're prepared, I'll go forward on that, let you deal with the substance of the motions to dismiss. I have read through your material, so I get the gist of what the defendants are raising. Counsel, would you like to proceed?
Thank you, Your Honor. As we've briefed, Your Honor, the counts that are at issue in the motion to dismiss are counts 13, excuse me, the counts 10 through 13. They are infliction of emotional distress claims. As we have presented in our papers, none of the plaintiffs observed the alleged incident that is described in the complaint. None of the plaintiffs came upon the decedent in close enough proximity to state a claim for emotional distress. There is the cases, Your Honor, limit when a claimant can claim emotional distress. The cases talk about temporal, spatial, and relational limitations. Taking the claim that Kaylee Furbush has alleged, that claim is for negligence/reckless/intentional infliction of emotional distress. And the basis of that claim is that there was a discussion on the telephone or discussion after Karen Reed had left 34 Fairview in Canton and had somehow started to fabricate a story about what had taken place. Kaylee Furbush was not at the scene, and the perception of someone dying is not an actionable claim under any case that we can find in Massachusetts state law. So she wasn't at the scene, didn't come upon the decedent, and therefore doesn't have the same types of proof, at least is played in the complaint, that would satisfy the limitations that the case law sets out, the temporal, the spatial, and the relational. With respect to the claims of emotional distress that have been brought by John O'Keefe's mother, father, and brother, again, they were not witnesses to the event. They came upon him many hours later. There are cases, and particularly the Cohen case that is cited in our brief, that speaks to the time that passes between an alleged event and when a family member or a bystander witnesses the consequences of that alleged event. And in that Cohen case, the court speaks to the fact that the mother of a young man that died in a plane crash didn't get to find out about it until many, many, many hours later, and the court denied the right to pursue an emotional distress claim. More importantly, Your Honor, there is a remedy here. If for the sake of argument, there is a remedy here through the wrongful death statute. And the wrongful death statute compensates for the types of harms that are alleged in the complaint. So what we're asking the court to do is to dismiss out the emotional distress claims because they are duplicative and allow the plaintiffs to pursue the wrongful death action singularly. We rest on our papers. Thank you, Judge.
All right, thank you. So let's turn to the other defendants if they want to be heard. You've filed separate motions essentially arguing the same relief, but if you have anything you want to add, you certainly can. The Waterfall?
Yes, Your Honor, we have the Waterfall. Just very briefly, I think the distinction here the counsel's making is that these claims, these infliction of emotional distress claims are intended when you're in the zone of danger or you're a recipient witness. And in this instance, it's many, many hours later that the parents are seeing the decedent in the hospital. I think it's after 7:50 a.m. And so based on what the Cohen case states and in terms of the principles that the courts have applied here, it just isn't from a relational standpoint close enough in proximity to be able to advance this type of claim. And in terms of the wrongful death statute, those loss of consortium damages, the damages of the loss of the son, if the plaintiff is making this claim going forward, are in fact addressed in that statute and obviously would be available as remedies to the plaintiff.
What about Semino versus Milford Keg Incorporated? I have a 1982 case that I found talking about the wrongful death, emotional distress injuries. Have you reviewed that case? I'll give this case site, 385 Mass 323. It's a 1982 case. So it would seem to suggest that that emotional distress is really not preempted by the wrongful death statute.
Your Honor, I think the wrongful death statute alone would not necessarily cover all of the damages, but my argument would be more in line with the argument that in terms of where they are in relationship to the accident, since it wasn't witnessed and since it wasn't immediately thereafter that they came upon the scene in a roadway, in a driveway, and observed the decedent, I would argue, Your Honor, based on that, that that's a problem for the plaintiff moving forward, and that would be the court's consideration. I appreciate, Your Honor, that there are some differences in the wrongful death statute and emotional distress claims.
Okay. Thank you. Ferreter versus Daniel O'Connell Sons, a case that goes back to 1980, also kind of speaks to that issue too. Let's hear from CF McCarthy's on that. Anything else to add on the motions to dismiss? No. Okay. All right, great. All right, I'll take that issue under advisement. I do have some, I'll read through your briefs a little more closely.
Allow us to.
Yeah, of course. What I was going to say is that what will happen in just a few moments, I'm going to give the plaintiff an opportunity to respond to that. But I want everyone who's sitting here to understand that the comments I'm making now are not really doing other than just trying to tease out what the issues are. Motions to dismiss are not based upon the evidence, but rather on the allegations that are contained in the complaint. And those allegations, for purposes of a motion to dismiss, have to be accepted as true. And the question is whether or not the plaintiffs have stated a plausible claim under the case law, Iachino and others that deal with this issue. So with that context, plaintiff, if you want to respond to both the motions to dismiss raised by, I should say, both the two corporate defendants and Ms. Reed.
I do, Your Honor. Thank you. The question that's really posed for this court is, like you just said, assuming all facts are true, indulging every inference in the plaintiff's favor, does the plaintiff's complaint plausibly suggest that plaintiffs are entitled to relief? The answer is yes. This is a motion to dismiss. The lowest standard, the Brum case, plaintiff's obstacle is a minimal hurdle, a relatively light burden, so long as the court looks at the allegations holistically. If relief to the plaintiff is plausible by the cumulative effect of all the factual allegations pled, we survive the motion to dismiss standard and we move forward to discovery like we should in all cases and in this one. There are three arguments that my brothers have put forward in this case. We oppose all three of them as follows. Number one, the defendants incorrectly state the law by suggesting that NIED claims are subsumed or preempted by the wrongful death statute.
Here we go.
Number two, Your Honor, the defendants improperly seek to limit the scope of NIED claims by creating an arbitrary bright line test for such cases. Number three, Your Honor, the defendants failed to holistically consider the facts alleged and the known vulnerabilities of the plaintiffs when evaluating the defendant's extreme and outrageous conduct in violation of the infliction of emotional distress standard. I recognize that this court is not new to this case, and I recognize that most people already understand the facts, but I think it is important and significant that I at least highlight the ones that will be at issue here today. Throughout, we intend, like we did in the complaint, to refer to John O'Keefe as JJ. That is what he was affectionately referred to by his niece and nephew. JJ no longer has a voice. His life was wrongfully taken on January 29th, 2022.
JJ.
He lived a life of service. He was a Boston police officer, and his personal life, when JJ's older sister and brother-in-law tragically passed 2 months apart from each other, leaving two young children orphaned, JJ stepped up. He agreed to parent those children, to raise them as his own, and to support them. Fast forward to 2022, Your Honor. JJ is involved in a relationship with Miss Reed. It's been going on for a period of time at that time. January 29th, 2022, Karen drives drunk. She reverses her SUV. She knocks JJ down.
She leaves him to die in a
cold.
Oh my God.
And Reed knows.
Are they still saying this?
The plaintiff. Rather than seeking to help or calling 911, she returns to JJ's home. There, JJ's 14-year-old niece, Kaylee, a plaintiff in this case, is home alone, asleep. That's when Karen starts plotting. Now, it is significant for the facts for you to understand the context here. Karen Reed knows Kaylee well. She's been in her life for almost up to 2 years. She has served as a part-time maternal figure in her life. She knows that Kaylee is a vulnerable child, having lost two parents tragically. And 1 to 2 hours before JJ's body is ever found, before anybody knows his whereabouts, Karen Reed decides to wake up Kaylee in a panic. She tells Kaylee something happened to JJ. He's dead. He's been hit by a plow. Did I hit him? All to a 14-year-old child woken up from sleep who's already lost two parents. After provoking this chaos in the middle of the night, Miss Reed leaves Kaylee.
Chad, I couldn't hold it in anymore. That's emotional infliction of emotional distress. Is that what he's arguing?
Alone, vulnerable, shocked, and afraid. It's now 1 to 2 hours later. It's at or around 6 a.m. in the morning. JJ's injured body is now found. Right where Karen left him, buried in the snow, 911 is called. Now is when JJ's family learns of JJ's injury. JJ's injuries at this point enter into the O'Keefe's consciousness at around 6 a.m. They rush to the hospital. It's 7:50 a.m. That's when the hospital pronounces JJ dead. And within minutes of being pronounced dead, that's when the O'Keefe family sees their son in the injured state that he was in as a result of the wrongful conduct. From January 29th forward, Your Honor, Karen Reed plots, she fabricates a conspiracy, she launches a public campaign of disinformation, and she involves a blogger named Turtle Boy. She leaks not for public information through him. She pits her followers against the O'Keefe family, and all the while, Karen knows that the O'Keefe family is also vulnerable, grieving another tragedy in their family. The O'Keefes and Kaylee suffer severe emotional distress. It's more than anguish and more than grief, and it is not overlapping with the wrongful death statute. So the first argument that the defendants made, they claim that JJ's parents are precluded from bringing NIED claims because such damages are duplicative of the wrongful death statute. We reject that argument. JJ's parents are the next of kin, and their emotional distress claims are not preempted by the wrongful death statute. They took their first shot across the bow by making that their primary argument. Presumptively, they did so because it believed it's their best argument. But the problem with that argument, as Your Honor has already pointed out, it patently misstates Massachusetts law. You have pointed out the Cimino case, where, let me just point out first the wrongful death statute. It has two components for damages. It has two buckets of damages. It has the estate's damages. Those all are JJ's damages, his conscious pain and suffering, the medical bills, things that relate to his damages. And then we have the second bucket, the next of kin bucket. Those are lost value damages. The lost value of JJ being in his next of kin's life. And in that case, Your Honor, it is just the parents. Now, they suggest that those are overlapping with the NIED, but Your Honor was right to point out the Cimino case, where a drunk driver kills a 9-year-old boy. The father of that 9-year-old boy brings a case against the drunk and the bar for over-serving him. The father brings two separate causes of action, one for wrongful death, one for NIED, negligent infliction of emotional distress. The court held in that, and I quote, argument that plaintiff's claim for emotional distress is preempted by wrongful death action misconstrues the common law cause of action for emotional distress. Emotional distress, as the concept has evolved in the Commonwealth, is a severe psychological shock directly resulting from experiencing or witnessing the effects of the defendant's conduct. A claim for damages based on emotional distress, the court says, does not include an administrator's claim for loss of consortium, which will be present in every wrongful death action such as this. Since emotional distress is a wrong to plaintiff distinct from what was done to his son and the statutory beneficiaries of the decedent, it is not a duplicative remedy. It is not preempted by the wrongful death statute. And that's page 334 of the Cimino case, Your Honor. Cimino still remains good law. You were right to point that out. It directly contradicts everything that my brothers just argued here in this court. And I see no reason why this court should overturn the good standing law that exists under the Cimino. We ask that Your Honor deny the motion to dismiss for that first argument. The second argument that they make, Your Honor, is that the plaintiff's NIED claims are not sufficiently contemporaneous with the alleged accident because the family sees JJ 7 hours after the accident. That the law does not endorse such a narrow, arbitrary interpretation of the law. It is misplaced for the defendants to focus arbitrarily on the time of the accident, because let's look at the law itself. The liability for NIED depends on a number of factors: where, when, and how the injury enters into the consciousness of the plaintiffs. And it also requires the degree of relationship between those plaintiffs. But I repeat, where, when, and how the injury enters into their consciousness. It is misplaced for the defendants to suggest that it matters that plaintiffs were not at the scene of the accident, because as you pointed out, the Faraday case stands in the exact opposite.
I love an AJ look like this. I just do. It's perfect timing.
Where the plaintiff who rushes onto the scene and finds his loved ones injured has no greater entitlement to emotional distress for that shock than a plaintiff who rushes to the hospital, so long as the shock follows closely on the heels of. It is misplaced for the defendants also to suggest that there is a bright line test for the number of hours that passes between the time of an accident and when the injury enters into the consciousness of the plaintiffs. Your Honor has persuasive authority from the Zachary case that shows that an NIED case can survive even when the close family doesn't see the deceased body or the injured body until a day later after the wrongdoing. There is no bright line test. NIED is a fact-intensive analysis. And when we apply the law to the facts of this case, let's look at where, when, and how the injury enters into the consciousness of the people that we're bringing those cases for. It's 12:30 a.m. and nobody except Karen Reed knows about JJ's injuries. Defendant's wrongdoing continues into those early hours. She knows she struck him. She seeks no medical help. Instead, she chooses to cover it up and hides the injuries from anyone. It's not until 6 a.m. that JJ's injuries are even capable of getting into anyone's consciousness. The O'Keefe family immediately learns of JJ's injury, and they closely on the heels, they rush to the hospital, at which time they see the deceased body within minutes of him being declared dead. It is incredulous to think that a wrongdoer who hides the wrongdoing and the injury from anybody can be relieved of liability simply because the injury becomes knowable only after they disclose it. The defendant's cited cases are inapposite. They have no relationship to what is being asked of this court. They all involve a motion for summary judgment standard, which is a very different standard than the one that we are talking about here today, the motion to dismiss, the lowest hurdle to overcome. They try to equate it to a mother who learns of the rape of her daughter 7 months later, but that rape was known to other people within days. They try to relate it to the Migliore case, which has no relevance because it deals with somebody who has no close relationship. They didn't even know the decedent, and therefore it doesn't meet that standard. And then they rely on the Cohen case, which I heard both sides try to suggest has relevance. But in that case, Your Honor, the mother learns of her son's death 7 hours after the death. That's 7 hours after the injury occurred. And by the way, it was already knowable 7 hours earlier by other people when
Oh my God.
plane crash was projected, and the son of the woman who brought the claim knew about her own, his brother's death. The mother is 1,000 miles away, so spatial proximity is not there, and she only learns of it via phone. Does not experience the injury and never sees the body. Contrast that with everything that we talked about, Your Honor, where as soon as it was knowable, they learned about it, they rushed to the hospital, they saw the body, and they saw the body within minutes of him being declared dead. The purpose of the law is to distinguish between emotional distress from perceiving an injury versus the expected anguish that any person would feel from the death of a loved one. I want to talk briefly about Kaylee and her NIED claim to suggest because she wasn't at the scene or because she was not at the hospital that day and they tried to spare her of that does not suggest she doesn't have a right. In fact, she experiences the trauma, the panic, the chaos of the injury contemporaneous with Karen Reed waking her up in the middle of the night and exclaiming that her parental figure, the third that she has now lost, was dead, hit by a plow or her SUV. Notably, this enters into her consciousness before anyone other than the wrongdoer knows of the injury. To the extent that defendant seeks relief because Kaylee did not see with her own 2 eyes, I will refer you also to the Cohen case, which they cite for different reasons, but in it, the language talks about sensory perceptions to suggest that you can't use other senses in order to perceive and experience the injury or the injurious event is wrong. Otherwise, no blind person would have a legal right under NIED. We have many senses. We use them all the time.
Okay, he's losing me a little bit. But real quick, shout out to Kay Schmidt, waking us up, sent out 5 AV memberships. Thank you so much, Kay, for doing that. Mila got a membership. Latina got a membership. Shauna got a membership. Mama Boo got one. And Destiny received a membership from Kay. Thank you so much, sis. I always love to shout out memberships. Memberships really drive this channel. Our videos are powered by our members. Whenever I need advice, I go back there into the members only community and I ask you guys what we should do for content. We run ideas by you. So really, really looking forward to all the people that became members. Looks like we have about 23 minutes left on this one, but let's go back to the debauchery because this is John O'Keefe's family. This is their civil suit against not only Karen Reed, but the Waterfall Bar and Grill and the additional bar as well. I forget, CF McCarthy's. So this is the O'Keefe family lawyer kind of explaining what's going on here. And again, he keeps referencing that Karen left John to die and all this stuff. And it's like, she just got acquitted for this, right? Like, what are you talking about?
And when it enters into our consciousness, it's
again,
hard
Kay.
to undo of it. It is very different from learning that your close family member has died. That is upsetting. It will be upsetting to anybody. But to have experienced the event or the injury and enters into your consciousness, that is the very reason and the foundation why NIED exists as a claim. So on that second, we also suggest that you should deny it because they experience the injuries. Closely on the heels of them being knowable and perceivable to anybody. Third, Your Honor, the defendants argue that the intentional/reckless infliction of emotional distress claim should fail because there's no extreme or outrageous conduct directed towards the plaintiff. But when viewed holistically, the facts demonstrate that Ms. Reed should have known her extreme and outrageous conduct would be detrimental to these vulnerable plaintiffs. And I use the word vulnerable plaintiffs because it's relevant to our case law, Your Honor. It's misplaced to suggest that the conduct needs to be directed immediately towards those plaintiffs. As long as she should have known that the emotional distress was the likely result of her conduct, that's sufficient under the reckless infliction of emotional distress standard. So how do we evaluate what is extreme and outrageous? It's fact intensive, but the law does recognize that some critically important factors that need to be considered when evaluating what is extreme and outrageous. Plaintiff's susceptibility, defendant's knowledge of that susceptibility, and the relationship between defendant and plaintiff. The case law all suggests that that gives rise to extreme and outrageous conduct. In evaluating whether defendant's conduct was extreme and outrageous, the courts should consider whether individuals at whom conduct is directed is known to be particularly susceptible to infliction of emotional distress. Boyle versus Wenck, 1979 case we cited to, Your Honor. Our case law has recognized susceptibilities to evaluate extreme and outrageous conduct to be a recent hospitalization in the Boyle case, a cancer patient in the Harrison case, elderly or frail people in the Bailey case, or children, minors, based on their age in the Sarkonis case, all that we've cited to, Your Honor, and I'm happy to give you cites. The law in Roman versus Trustees of Tufts College says, as it relates to this, the court should put as harsh a face on the defendant's actions as the basic facts would reasonably allow. The relationship of a plaintiff to the defendant and her knowledge of the plaintiff's sensitivities is an important consideration in determining whether the challenge conduct satisfies the extreme and outrageous conduct. That's the Russell case.
Okay, we got some buffering action.
Let's talk about Kaylee as it relates to the infliction of emotional distress. Should defendant Karen Reed have known that emotional distress was the likely result of her conduct? Was defendant's conduct extreme and outrageous? Those are the questions that ultimately we pose to a jury. Kaylee was young, 14 years old. The defendant had a relationship with her, knew she was emotionally fragile, knew she was orphaned at the age of 6, knew that she lost both parents tragically. The defendant assumed this pseudo-parental role with Kaylee for nearly up to 2 years. The defendant, Ms. Reed, knows that she knocked JJ down. It's the middle of the night. She wakes up Kaylee abruptly. She talks about JJ being dead, being struck by a plow, being struck by a vehicle. Mind you, this is all hours before anybody has even discovered his body, and she is now actively talking about him being dead. Then, after creating this chaotic, upsetting situation in this young, fragile girl's psyche, she leaves her. She leaves her home alone, shocked and frightened. Compound that by defendant's choice to speak her false narrative publicly, to use social media, to leak public information through Turtle Boy, to control that narrative. Why is Turtle Boy out there saying the O'Keefe's family period of grief has expired and they are now fair game? Who leaked the autopsy photos that got published by Turtle Boy for this vulnerable family to have to be exposed to that they weren't seen before? To the extent that the defendant argues that this is not extreme and outrageous, remember the law. It is the jury's role to decide whether the defendant's conduct was rude and clumsy or extreme and outrageous. That comes right from the family, Your Honor. Should the defendant...
Okay, they got all glitchy over here. Okay, all right. I don't know what happened there.
This defendant's conduct extreme.
Why is he moving like that?
Again, those are the questions posed for a jury ultimately. But the law says conduct which the actor should have known would result in distress is actionable. And the plausibility standard, the motion to dismiss standard, which is where we're at right now, Your Honor, simply calls for enough facts to raise a reasonable expectation that discovery will reveal evidence of the illegal conduct. Margaret and John have now buried 2 children. Paul has buried all his siblings. Defendant always knew this. She has always known their vulnerability, and yet she creates a calculated and malicious campaign of disinformation designed to hide the truth in this case. She pits the O'Keefe family versus the Reed family, and a reporter who she asserts editorial control publicly proclaims to Reed supporters, the O'Keefe family's period of grief has expired and they are now fair game. Discovery will track how much leaked information defendant should have known would result in distress to the O'Keefe family. To the extent that the defendant suggests that this case fits nicely within any other case decided on this issue, remember the facts and circumstances here are exceptional. We wouldn't have these TV cameras or a full courthouse if they weren't exceptional. That is why we are here, Your Honor. It doesn't fit within a nice box like every one of those cases I cite. The Pillay case where we talked about false police reports and harassment petitions were not considered towards emotional distress because they were petitioning activity. I want to talk about that briefly, because what Ms. Reed has done is not petitioning activity. It is not asserting a defense within a courthouse or having her legal counsel assert that defense or testifying at a court hearing. Instead, what Karen Reed is doing is not petitioning at all. She is waiving her Fifth Amendment privilege. She's speaking anywhere and everywhere that would give her a friendly audience with editorial control. She's gone on Dateline, Nightline, 2020, Fox 25, Boston Magazine, Vanity Fair, WEEI, Turtle Boy, HBO Max, ID Discovery, etc. There are more.
Well, whoop-de-doo.
This is an exceptional case that requires exceptional discovery, that requires us to decide this matter by a jury, not by a motion to dismiss phase, Your Honor. It is not like
they were super glitchy this day.
involved, and so they think that's not extreme and outrageous. And it's not extreme and outrageous like the, it has nothing to do with the employment case where they fired somebody who had a criminal case pending, then they brought them back on, and he didn't like the way that they treated him after he was found not guilty, which is different, by the way, than innocent. The court should deny the third of those arguments. They should know that plaintiff's susceptibility and vulnerability are at issue in this case and are the very reason and foundation why it is extreme and outrageous conduct, and that defendants' improper actions would cause severe emotional distress. Defendants' actions were not rude and clumsy. They were extreme and outrageous. We ask Your Honor to allow this case to go forward with discovery, allow us to explore each and every one of those issues, because these are real damages for real people who have suffered long enough. Thank you.
All right, thank you.
Wow.
Any response from the defense?
Your Honor, briefly. Firstly, those allegations contained in the complaint are allegations which we will refute. Counsel cites to the Camino case, relies heavily on it. What counsel didn't tell the court is that in the Camino case, the father of the child who died in the car accident was himself hit. Part of the car accident, gets up, runs to see his son. It's contemporaneous, it's at the time of the event, and the court didn't have the same spatial, relational, and temporal concerns that the cases speak to with respect to emotional distress claims. So I point that out for the Your Honor. He also mentioned much about conspiracy theories, much about going out in the public and creating a narrative, which is precisely the reason why we're going to brief the issue about why those other parties need to be in this case. As I'd said, it is more than just a wrongful death action, Your Honor. I respect the opportunity to brief that, and we rely on our papers and defer to the court on the motion to dismiss.
All right, thank you. Any other defendants wish to be heard on the issue? Anything else? All right, thank you. Certainly, there's a lot to the complaint. And again, for the record, so that people understand this, this is a pre-discovery form of relief that the defendants have sought by way of dismissing certain of the counts that are in this complaint. And the court has to consider the allegations as being truthful and every reasonable inference to be drawn in support of that. So I will look forward to reviewing that. I'll issue a decision as soon as I can. As expected, the lawyers in this case have advocated the positions of their clients very clearly, and I expect that with the procedural things that it might be asked for at some point, that this case will have a very long and tail to it as it goes through the litigation process. We expect that in the court system, we give people their ability to try cases and get a jury to listen to the arguments and to ultimately make a decision. My experience in doing this for a very long time in different contexts is that doesn't oftentimes bring the relief that people think it does. And so as a result, there's appellate processes. And so what I envision for the parties, unfortunately in this case, is a very long and sort of complex process that litigation provides. And you know, this is a civil case. It's not a criminal case. There are 8 parties as I identified, and those are the people that the court will be concerned with getting a fair trial at some point down the road. As I said, I could do this case, I could do this trial this spring if you'd like to. My sense is that there's nobody that's going to be ready to go to trial by the springtime. If you want me to sign a trial date, we could do so. I mean, literally, I've talked to the clerk, we could do it in March or April.
Wow.
But with the motions that are going to be pending, I suspect that that's not going to be the case, that you'll have to look at this from a more pragmatic point of view and decide when you're going to try to get this thing to a jury. You have a lot of work to do between then and now. I'd like to still get a trial date for you. Now, I don't know what that's going to mean in terms of bringing in other parties. You know, I didn't expect, because the court has had no notice, that there'd be this interest in trying to move this complaint in the direction of other parties who aren't even named in this lawsuit, 10 additional parties. And there's relatively novel theories as I'm hearing it, but nonetheless, we'll let the parties file the motions that they need to, and we'll address them as each comes. But my point in raising this all is that the parties also have another way to do this case. They can do it by way of potential resolution. And I mean this sincerely when I say that being a judge for many years, you learn things. What you learn is that oftentimes litigation is an inartful way to try to resolve parties' disputes. There's alternative dispute resolution, there's mediation, there's all kinds of other avenues that we advance to try to get people what they want, which is resolution of a case. The most important thing, it would seem to me, to any party to this case, is to resolve the uncertainty, right? Uncertainty is what you don't get when you go through the litigation process. You go through and you hope for the best. Lawyers work really hard for their clients, and we expect them to do that. Ultimately, the court system can make sure that the trial is done, and it's done in a way that's fairest that we can make it. And ultimately, a decision is made. Civil cases, though, are very unlike criminal cases, and that's usually not the end. Ask any of the lawyers here, clients can ask your lawyers about post-disposition or post-verdict process. It can be really long and arduous. I've had the pleasure of having trials that are 16, 18, 20 years old, and they're still going. Your clients don't have to do that. the clients can try to put some efforts, at least as much effort in the litigation process as trying to resolve it. Why do I say that? Because resolving cases resolves uncertainty, which is perhaps the most important thing any client can get in a case. I say that because you'll have that opportunity through all the process. You've heard me outline it. Your discovery isn't even closing until the discovery is going to close next December, but it's really 2027 that you're looking for a trial in this case realistically. Again, we could do it in 2026 in the spring if you want to. And I'm going to ask the parties to work collaboratively to try to come up with a trial date that is workable. I understand that's a wrench has been thrown into the works because of this other process. We'll probably have to deal with that in the short term. I'll pledge to try to get you what you can as quickly as I can. I tend to get decisions out pretty quickly. I tend to try to move things to get parties what they want, which is ultimately their day in court. I'm just telling you at the outset that I think that it's worthy of exploring possible resolutions on your own. You can do it through this court. We have a mediation process that you can avail yourselves of, judicial settlement conferences. You can go through private neutrals, because there are now 8 parties involved in this case, 2 of which are corporate defendants, 1 of which is Ms. Reed. And so that's going to give you a lot of opportunity for dialogue. My sense is I'm probably wasting my time by doing it at this stage of the process, but I think it's important that your clients know that there is an alternative way out of this. Money damages are all the plaintiff can ask for. Nobody can restore, we say this when people lose loved ones or that they have some meaningful part of their body or mind that's been lost in a litigation. We can't restore that. We award money damages. And so ultimately that's what the imperfect litigation system will have. Knowing that, there's a huge opportunity to try to resolve a case like this. And I would urge the parties to have very frank discussions with their lawyers about that and ask yourselves, is it worth going forward with all the uncertainty? And I'm not going to explore with your clients what everybody has to lose. Everyone knows that. If I were representing a plaintiff in this case, I would tell them all about things like the time it takes to get to litigation, how what we have the burden of proof. Yes, it's easier with a burden of proof that's by a more likely than not standard versus a proof beyond a reasonable doubt, but still it's a burden of proof nonetheless. But there's a time value of money. People don't, getting this behind them is an important issue. From the defendant's point of view, again, time is money. There's a lot of time, effort, and anxiety that is put together with a litigation like this. We have 2 ongoing, as far as I understand, the 2 businesses in Canton are ongoing, and they have their business decisions they have to make ultimately. They're defendants in this case. They have to understand the risk of going forward in a trial versus resolution. Of course, Ms. Reed herself, a lifetime of potentially facing the uncertainty of a judgment and what that will mean in terms of ability to put this matter behind and going forward. It's going to be very complex. So you can resolve that by looking at putting some effort into this case to resolve it. If you can, great. If not, we stand here committed to giving you the next opportunity to get it before a jury, which I'm suggesting to you could do as soon as this spring, if you want to. Okay. Anything else we need to address this afternoon?
Not from the defendant, Your Honor.
Okay, great. I'll issue a decision on the motion to dismiss. Tracking order stays in place as it is now, but here's my concern, folks. With this motion that the defense team is talking about putting together, I think that needs to be looked at sooner rather than later. It's a big deal, right?
Yes, Your Honor.
Okay. Why don't we get a status date? When do you want to? And we can do by Zoom, folks, if it's just as easy. My order was to have everybody here so that you all get a chance to meet. I want people to be understanding that this is a civil matter, and I want you to be, at least to some extent, trying to be civil about how to resolve your issues. I would have liked to see, for instance, this motion that was brought about in open court should have really been discussed ahead of time so you have a better position on it, but I don't want to waste your time. You want to do next hearing by Zoom? You want to do it in person? You tell me. Plaintiff?
We're agnostic, Your Honor. I'll do what.
We're agnostic? Is that what you said?
Yeah, as it relates to that, we'll come in person or we'll do it via Zoom.
Defense?
Your Honor, we prefer to be in person.
Okay.
Either way, Your Honor.
Okay. All right, we'll do it in person. Fine, we'll do it down here in Plymouth. I will be moving into the Brockton court next month, but this is especially assigned, at least for now, so I'll come back down here. That's not a problem. Mr. Clerk, do you want to suggest a date for us?
Sure.
How many days out you want to go? 60 days, 90 days?
Yeah, probably 60 days.
50 days? November 21st, Friday in the end of November.
Yeah, that November 21st. Okay, I'll have a decision out before then, certainly, as quickly as I can. 11/21, and that would be for a status regarding tracking order and discovery, and any motions, Rule 15 motions to amend or bring in third parties. Okay, all right, thank you, folks. We'll see you then.
Thank you, Your Honor.
All right, chat.
All right.
That concludes. I think that's all they have for that day.
Nothing with the jury?
I don't think so.
Nothing with the jury?
All right, that concludes the hearing for Karen Reed's civil case. So lots of news buzzing about the civil trial. So what you guys just watched, let me just explain through that a little bit. The original complaint was filed by the O'Keefe family. So they started this, the mother, the father, the brother, the O'Keefe family wanted to sue Karen civilly. Now they're also suing the Waterfall Bar and Grill, and they're also suing CF McCarthy's, which are the bars that John O'Keefe attended with Karen before that fateful night. Now, it's a wrongful death lawsuit. Okay, so if you think about it, there's already a lot of parties involved. Two of the parties are businesses, and the third party being Karen as the defendant. Now, the judge seems like he is really cautioning this group towards the end of that hearing. Why? Because he's really encouraging them to look at alternative dispute resolution. What that means is he's asking them to get together, possibly settle, because in a civil case, he mentioned it, the most you can really do here is money damages for pain and suffering, things like that. But when you settle, that is not one of the reasons why you end up in a courtroom. You do that outside of the courtroom, and then the case does not move forward, right? So you settle and everything is done, right? It sounds like there is not an opportunity to settle with these parties, but here's the most important thing coming out of this. There is a request to add additional people in to this lawsuit. Those people include Brian Tully, Yuri Buchanan, the other police officer, the Massachusetts State Police, and all of the McAlberts and McCabe's, right? It's a lot of people. Now, the reason why the judge is cautioning them is because he's like, if you want to move forward with the case as is, and remember, Karen's team suggested bringing all these people in, right? The motion to dismiss, from what I can see, I don't believe he's ruled upon it yet. They set a new court date for November 21st, so we'll come back for that one and see what's happening then. But he's saying, if you want to add all of these additional people on, that's fine, but it's going to add some complexity to it. That means that we're not taking this to trial until 2027. That's a long time from now. Now, you got to think about Karen Reed. She's been going through this 2 trials and going through the civil case as well forever. It's been a few years. So to drag this into 2027, it's a risk, but at the same time, and a lot of you guys have been picking up on it, why should she have to pay for something that she did not do? It seems like Karen is fighting against this. Okay, so good for her for fighting. All interesting stuff here, but wow. I mean, I did not expect that. And a lot of people, this hearing was last week. A lot of people have been talking about it. I wanted to see it without, viewing others' opinions and things of the like. Lots of discussion about Turtle Boy on that one. I don't have a comment on that. You guys know my stance on that. Definitely want to stay out of that one. But there's some rumors going around about a recording right now. I don't know much about it, to be honest. I don't know if it is authentic, but there's allegedly some rough water between Karen Reed and Turtle Boy. I don't know. I'm just saying, I'm staying out of that one. Anywho, that is the latest on this. Now, we are getting back to a regular schedule programming. What I'm going to do when there's no active trial on is I am going to go live on Tuesdays and Thursdays, and we're going to call this the Power Hour. Today, we tested the 5 o'clock slot to see if it works. for different people's schedules. Thursday, we're going to try a 12 o'clock slot. And then moving forward, whichever time slot is most popular, and I will poll you guys behind the scenes as well, that will be the permanent shows. We'll do Tuesday and Thursday shows. So I'm really looking forward to doing these power hours. Diddy, the Diddy docket, the sentencing is this Friday. The prosecution wants 11 years. We don't know if he's going to be sentenced to 11 years. There have been many victim impact statements over these past few weeks. So Thursday's agenda, I'm really going to dive into that one. Also, I'm going to keep an eye open for this motion to dismiss. Maybe it happens this week. Y'all know I'm at Vid Summit next week. So there is a lot going on. What did you see in this episode of Power Hour? Now they have notes for us back here. We talked about David. I'm also still keeping an open mind on the David thing too, and eyes on the news. We're going to see as these things develop. We're going to keep an eye on that case. Poor Celeste Rivas. I feel so bad that this young lady lost her life at the age of 15. But I'm really curious on why a 15-year-old was found in an adult's vehicle. Right? Her body was found in that vehicle. It's a very sad case. We went down to Atlanta and we saw the shenanigans happening with Tyrese. And I really hope that the warrant gets settled with him, because you don't go on vacation. Like you're pulling a Donna Adelson. You're trying to are you trying to flee and go to Vietnam before an arrest happens? Like, it sounds very Donna-ish. It sounds very Queen Pin grandma-like to me. So very interesting stuff there. Talked about Thugga's update as well. So he is still not getting his stuff back until that appeal goes through. So very interesting stuff. Fani Willis, DOJ. Wow. The Department of Justice wanting her travel records. Is that going to go in front of a grand jury? It's interesting stuff. There's no documents out on that one, but I'm very curious on that as well. And then, of course, we just covered Karen Reed. So channel announcements, we talked about the Power Hour new schedule. I am going to be launching a new channel for creators. So there will be a second channel. I'll probably give you more details on that on Thursday. And then Vid Summit, I'm super excited. For those that are in the Dallas area, I will see if we can set something up. But I will be in Dallas next week speaking at Vid Summit. Super huge opportunity. All your favorite creators are going to be there. I'm just pumped to meet everybody. Legal Eagle, Roberto Blake, Daryl Eves, Mr. Beast, like whoever you have watched on this platform is likely going to be there. So huge opportunity. And that's why the channel's been a little bit more quiet these days, been really focused on creator stuff, so really excited about that. Before I run, let's catch up with some super chats, keep the conversations going, and just make sure I got all of you guys. I think we left off with Senator. Thank you again for the $5 super chat. And you guys check out Senator's channel. Shout out to D with the 5, says Fanny's going to change her name to Lanny or Lani after taking all these L's. Yeah, she's taken quite a bit. This has not been a good month for Fanny. So we will see what continues to happen down in the state of Georgia. Shout out to Brother Irwin. Good to see you. Great big smile in that photo. Hits me with a $10 super chat. Says, AV, what it do? What it do? I know Brother Irwin changed his name recently from E. Capone. So thank you so much. And you just reminded me, coming over to the Cash App crew. Thank you so much to everybody that supports on Cash App. You guys know that YouTube plays its games with the algorithm and all this stuff. So I always appreciate the folks that support the channel on Cash App and Venmo as well. Shout out to Jerome, hits me with a 5. Thank you so much, Jerome. He says, nice to see you back. Yes, we are back. We are back at it. And we've got a ton of content coming your way. Thank you so much. E. Capone has also been with me for 19 months, celebrating a milestone. And for those that don't know, if you are a member, I think once a month you can use one of your perks of your membership is to have like a free highlighted comment like this in the chat. So thank you so much, E. Capone, for your time with me. Oh, and speaking of that, I got a few meetings next week. They want to do, not even they, we will have a AV app, right? I'm just talking to a few people right now, but we're really excited about it. Okay. So shout out to us. We have been working on it. There are a lot of people that want us off of StreamYard and on their platform. They know that there's an opportunity for trial streaming on an app, and it will make it easier. So for our members and just anybody in the community, I may ask you some questions about how you watch trials, how you like to take in your legal content. So if you're watching us on a TV, that makes us pick through all the proposals, because really it needs to be the best viewing experience for you, dear viewer, you watching. I want to make sure that they're not gonna mess our stuff up, and I can still pull up super chats and things like that for you. So we're talking through all of that stuff right now. I'm really excited about it. It is such an honor. So I'm super, super pumped about that. So good to see you, E. Capone, because I was thinking about people in the membership community, so thank you so much. Shout out to Jamie with the 5. Thank you, Jamie. It's good to see you. Says, can the defense request or submit a motion so the plaintiffs would stop calling them brothers and sisters? Yeah, they should. That's actually part of while I was in law school up here in Mass. It's so funny. It's part of lawyer culture. They call themselves, or they do call opposing counsel brother counsel, right? That's why that channel name is a good. Martin did well picking that channel name, but sister counsel, brother counsel, things like that. It's mostly lawyers speak and courtroom decorum. So that's why you'll hear that. But what I've noticed in this hearing is they were skipping the word counsel and just saying, yeah, my brother. And it's just are y'all related? What are we talking about here? Thank you so much, Jamie. It's good to see you. And I appreciate the $5 super chat. Kay Schmidt, thanks again for gifting those 5 AV memberships. Very, very nice of you. Appreciate that. And then shout out to Trainwreck Entertainment, ended us off with, she's been with me for 14 months. Good to see you guys. Trainwreck Entertainment is a husband and wife team, and they have amazing videos of day-to-day courtroom proceedings. And there is a favorite judge that they really, really work with over there. So please check out their channel if you have not already. She says, happy early birthday. Yeah, it's a busy week for me, guys, but still need to figure out my travel to Vid Summit. But yes, Tuesday, Thursday, got some videos dropping over the weekend. Likely going to do a birthday stream on Sunday. And then next week, I think I'm in Dallas on Tuesday, but we should be clear for Power Hour, and we will have our Tuesday and Thursday streams. Yes, YT Johnson, I am data gathering to best serve the people. That's what I do. Yes, Sheep in a Rowboat Art says, Judge Boyd, she's great. Love her trials. Yes, a lot of people love Judge Boyd over there. So please check out Trainwreck Entertainment. If you're watching me on replay, what we're going to do is put this into chapters so you can skip through the stories, and that's going to be our format. Moving forward, waiting to hear back from Brian Steele, but Brian did tell me that he needed to settle the Diddy stuff first before he can agree to come on to the channel. So that's my it's probably the biggest interview of the year. I'm super excited about that one. This is gonna be huge. I cannot wait to have Brian Steele on the channel. So if you are a member, I will be asking you guys and fielding some questions so we can get Brian prepped for that interview as well. Shout out to Love's Curly Hair. It's good to see you. Been with me for 11 months. Says, hey everyone, happy birthday. Yeah, it's on Sunday. It's coming. Little Libra, so it's coming. Almost there, right? Big 3-6. I know I don't look it, but the big 3-6. Thank you so much, Love's Curly Hair. Hope you are safe out there on the airlines doing what you need to do to help people travel. Good to see you, Love's Curly Hair. Mr. Wrench Turner. Good to see you with the 20. Says, Dallas, welcome to the city. You're going to love it here. It's been on my short list of places to move. So, Wrench, I haven't seen you in forever, brother. How are you? I hope you are doing well. But yeah, no, that is next week. I'll be in town for a little bit. Got a lot of people to catch up with, but it'll be great to see you and others, Wrench. But good to see you today. All right, y'all. I think I'm going to pop on out of here. That concludes all of our super chats, everything going on. Hope you enjoy the new format that we have. Again, Power Hour, Tuesdays and Thursdays, all things legal news, law, true crime, all of it. A little bit of tea, a little bit of legal, breaking it down for the everyday people. All right, y'all. Have a wonderful evening. I will see you on Thursday. Stay safe out there. Bye.